by the applicants in that matter. And I note in particular that ICA was the first applicant and Mr. Crawford Brown was the second applicant. Do you confirm that?
I can confirm that. I don't quite know what the distinction is, but certainly on the papers that was what the position was. Thank you.
And amongst about the 7 respondents, you were the second respondents in the matter?
Yes, I was. As is customary with some kinds of matters, the President is called as the first respondent, and the President would delegate that responsibility. It happened in this matter as well. Thank you.
In paragraph 72 of your statement on page 29, you indicate that the application was dismissed with cost, making the issues raised there in res judicata. And you refer to the annexed court orders. Am I correct?
I am correct. You are correct. The annexed court order is annexed as TM1, pages 32 to 47 of my bundle, Commissioners. It spells out in detail how the Cape of Good Hope High Court or Provincial Division arrived at the decision it did. And what follows over the next few pages are comments on the next set of review applications, leave to appeal to the Cape High Court, and then SCA and the Constitutional Court. All of those are now matters of record. The submission I make at paragraph 72, therefore, is, Commissioners, that given the extent of legal journey that this matter has walked, I submit that it's res judicata. Thank you.
Maybe let me take you to then page 45 of the actual judgment of the Cape of Good Hope. Page 45 of the bundle and paragraph 45, judgment. I will read the paragraph 45 into the record and I will ask for your comment thereafter. It reads, in my view, there is merit in at least 2 of the principal defenses put forward by the Respondents' Council, and I take it the Respondent Council will be counsel acting amongst others on your behalf, Minister?
That's correct.
The real thrust of applicants' complaint in this matter is that massive funds have been committed by the government to the acquisition of arms, which this country do not need, whereas the funds should have been used for poverty alleviation. That being so, applicants' attack should have focused on the real and effective decision to acquire these arms, namely that of Cabinet. That decision should have been made the primary object of the review application. In applicant's notice of motion, there is an alternative prayer attacking the Cabinet's decision, but this is only a consequential attack, dependent upon the invalidity of the second respondent's decision being established. This approach, with respect, putting the cart before the horse. The primary attack should have been directed against the Cabinet's decision, with perhaps a consequential attack on a secondary decision to raise funds. Applicants for the Cabinet decision and all documents that were before the Cabinet were not properly analyzed at all in the present review application. The Cabinet decision must accordingly be accepted as having been a valid decision. Once that is accepted.
Much, Commissioners. I think there are, firstly, I was very relieved at the quality of the judgment, because I think it put matters beyond in the same way as we have the responsibility of poverty relief. I indicated just before the tea break that we discharged that responsibility with aplomb. We need to remind ourselves that Clause 198 of our Constitution also requires national security as an imperative. And these things go hand in hand, and we dealt with these in a composite way. I think that the spirit of that is confirmed by the court. I think it's also very important, Commissioners, to recognize that beyond that rejected the application. So I think it deals with the matter for once and for all, and I wish it were so in fact. But legally, I think that the matter is dispensed of. Thank you.
Yeah, if I also can then move on in paragraph 46 of the judgment, I think that it deals with the so-called warnings that were given to you before you signed.
As a means of relief,
Rationality is squarely based upon the existence of the warnings contained in the affordability report. These warnings must, however, be read in the context of the document as a whole. They are contained in the report which purported to provide advice to the government in regard to the affordability of the proposed acquisition. The object of the warnings in the report is to bring possible negative consequences of the decision to the attention of the decision maker. The thrust of the warnings is not to advise the decision maker to desist from concluding the transactions in question. The real thrust is to inform the decision maker what risks to take into account if he does not proceed with entering into the loan agreements. Other elements of the report are quite positive. For example, the comments on the method of financing referred to in paragraph 24 above. It is relevant furthermore that the affordability report with the warnings was before Cabinet when it took the decision to acquire the arms in question. It must be accepted that, therefore, Cabinet approved of the arms acquisition with full knowledge of the warnings. Can you just respond on that?
Thank you very much, Commissioners. I think that what paragraph 46 of the judgment does for me is to confirm by external parties, the judges in question, that the decisions we took were rational and well-informed, well-grounded decisions. I'll also remind Drew, which says that affordability is ultimately a question of political choice. We'd analyzed the choices in the context of our constitutional imperatives. We recognized what was affordable, and we took the best decisions at balance. And I think that taking account of risks is what paragraph 46 affirms. And I think that in his testimony before the Commission, Mr. Donaldson had dealt with this matter at some length. Thank you.
Thanks, Minister. I will then read the last paragraph 47 into the record and then ask for your final comment on it. It reads as follows. In this case, second respondent, referring to yourself, said that he did apply his mind to the affordability report, including the warnings. It is tried law that the test on review is not whether this court agrees or disagrees with the decision in question. And there's reference to the decision of Belporto School Governing Body and others, versus Premier, Western Cape and others, 2002, Volume 3, SA 265, Constitutional Court in paragraph 45 at 282 F to G, which says, the fact that there may be more than one rational way of dealing with a particular problem does not make the choice of one rather than the others an irrational decision. The making of such choices is within the domain of the executive. Courts cannot interfere with rational decisions of the executive that have been made lawfully on the grounds that they consider that a different decision would have been preferable, close quote. To continue on the very same paragraph, the question when rationality is the yardstick is whether the decision is so irrational that no rational person would have taken it. By mainly focusing on the warnings, applicants have not established such irrationality in this case. I'm according of the view that there is no merit in the review. Your comment?
If I could say Bua and Tati, I would, but I'm not allowed to in the House, so I will say I concur fully with the views expressed in the judgment.
Thank you, Minister. Let me just take you back then to page 44 of the same judgment. It will be my last take on the judgment itself. There has been a lot of criticism wherein it was stated that the signing of the loan agreements were not in compliance to the Exchequer Act, and therefore they should have been invalid. And I take it that in the very same application, the very same arguments were raised. Can I take you to page 44 of the bundle, paragraph 40 of the judgment? And the last sentence of paragraph 40, it says there, the various allegations in the affidavits that the agreements were invalid by reason of particular statutory provisions were not pursued in argument. Can you just comment on that?
Thank you very much, Mr. Mpacha. They could not be pursued in argument because I think they are invalid ab initio. We've been able to demonstrate how our actions were informed both by an interim constitution and a final constitution, and how we'd interpreted legislation both in transition from exchequer to well, as with the constitution, the transition from the Exchequer Act to the Public Finance Management Act. And I think that we demonstrated due care and attention to the detail of what we were doing. Thank you.
Thank you. If we then can proceed back to page 29 of your statement. I think paragraph 73, 74, 75 basically refer to the findings of the court judgment. I don't know if you want to add anything on those paragraphs.
No, I think we've canvassed it by both, well, 73, 74, and 75. I think articulated in the judgment as reported, and just a little rider that there was no challenge to the decision of Cabinet which gave rise to the loan agreements, and therefore the decisions of Cabinet must have been taken to have been valid by the applicants in the matter, and you know, I think it informs why my submission is that this matter is res judicata. Thank you.
Now let's proceed to page 30 and deal with the conclusion. I will leave it to you, Minister, to deal with those paragraphs in conclusion.
Thank you very much, Commissioners. Paragraph 76 merely alludes to what I raised earlier, and that is that the submission of the National Treasury encapsulates the factual material on which this submission draws. And I stand by the probity of the contributions that the National Treasury and the IMC made to securing the integrity of the recommendations placed before Cabinet and relied on by it. I was convinced that the selected package was affordable and within government's fiscal envelope. My understanding of the failed court litigation that was launched against me as Minister of Finance is that the courts were satisfied that my conduct and the decisions taken were consistent with the mandate conferred on me. In closing, it's important to emphasize that as Minister of Finance, I was part of a collective, and though the core mandate I discharged was that of evaluating the affordability of the options assessed to realize the SDPP, I discharged those responsibilities as a member of the National Executive. Paragraph 79, Commissioner, reminds us that I wasn't party to deciding on the selection of equipment. In this regard, I was advised and accepted that National Treasury did not have the particular skill to offer advice on the technical capability of the equipment procured, but this would not be unique. The Treasury in its function is transversal to government. We don't decide on pharmaceuticals to be dispensed at clinics, nor do we decide on the content, curriculum content in education. We have a responsibility to be convinced of public finance obligations, and then of the ability and affordability, the ability to pay for that skill, and paragraph 79 deals with that. What I'd like to do is to give this Commission a view on the impact of cancelling the loans that were secured to finance the SDPP. In a nutshell, not only would South Africa's credit rating as a country be impacted, and this country now waits for 2 credit agencies to give us a rating on Friday this week, but so would all credit facilities obtained in the global credit markets. Credit markets everywhere are determined by trustworthiness and the ability to pay. And cancelling loans after such a long period would basically say that we are a poor taker. We would not be able to raise any deficit financing in the country. And I think the impact would be felt most particularly on the poor who are exclusively dependent on public services because they can't afford to go anywhere else. So we would then be seen as a non-investment grade. In a nutshell, the consequences of cancellation of loan contracts would have a profoundly negative impact on South Africa's creditworthiness and the perceptions of constitutional continuity. I'm not a minister any longer, but I do believe that constitutional continuity is of the essence. Thank you very much, Chairperson, Commissioners.
Yeah. Minister, maybe before I excuse you, or you're excused by the commissioners. Now, having championed the National Development Plan, what would be the effect of this cancellation on the NDP?
Commissioners, if one looks at the NDP, we drew very extensively from our constitution. In fact, the NDP and some of the work still to be completed would include trying to give effect to the security of citizenship of South Africa. It's not canvassed in the NDP as it exists, but the NPC, National Planning Commission, has it on its agenda. But if we, you see, the basic point, I think, is one that I've tried to articulate now. What government spends, it finances through taxes and what it can borrow. I explained that we need to be exceedingly cautious in how much we borrow because the debt service costs would be the first charge. If we can't borrow, then we can only have available what we can raise as taxes. The economy is likely to be in decline and we will face a diminishing ability to raise revenue even from South African taxpayers. And I think, as I'd like to repeat the point, the idea to implement all of this National Development Plan, which deals with a series of social obligations, but also infrastructure and job creation in the economy will be severely undermined. And I think we'll come back to the point then to try and understand that as a nation we would be a lot more insecure. Thank you.
Thanks, Chair. That concludes the evidence of Mr. Trevor Manuel. Thank you.
Advocate De Vos, does the clients have, do you have any instructions to cross-examine Mr. Manuel?
Yes, Chair, we do have instructions to request the opportunity to cross-examine. I have also been informed that Mr. Crawford Brown would also like to cross-examine the witness. He is in court. He is here.
Yeah, I'll come to Mr. Crawford Brown. I'll prefer to have the order where you first cross-examine and thereafter Mr. Taylor Crawford Brown, if we do grant him permission to cross-examine.
In that case, Commissioners, I'm going to request for an adjournment for this afternoon to give me the opportunity to prepare a proper and coherent cross-examination. I only received the statement of the Minister yesterday afternoon at around about 6 o'clock, and as the Commissioners know, I used last night to prepare for Mr. Lekota's cross-examination. I do not mean to delay the proceedings, but I would ask for the opportunity of the afternoon and overnight to prepare, and I will be in a position to cross-examine tomorrow morning at 10 o'clock, and I do not intend to keep the Commission for much longer than about an hour and a half at the most.
Thank you. Mr. Crawford Brown, I suppose you also intend to cross-examine.
Commissioner, yes, I do. I'm still awaiting the bundle of documents that are for pagination. They are being photocopied at the moment by the Commission and then will be circulated. So, until I receive those, I do not know what the pagination numbers are.
And I suppose the issues that we are going to raise, maybe let me say it up front, issues which have already been determined, particularly by the courts. Those issues are said to be res judicata. And I'm not sure that it will be appropriate for you to raise those issues here. Because once the courts have made a determination on a particular point, we as a Commission cannot overturn that. You understand that?
Commissioner, if I may, I believe there are some very serious allegations of perjury that would overrule that issue.
But then you understand what the legal position is. Once a determination has been made by a court of law, we are bound by that determination.
Sir, I understand that entirely, but the issue I'm raising is the use of perjury, which led consequently to that judgment against me.
I suppose, we are not here to deal with that. If at all you think that that judgment is incorrect, there are certain procedures that we can follow in order to get the judgment overturned. We cannot overturn it. But then we'll discuss those issues when we come to your cross-examination. For now, we're going to adjourn until tomorrow morning, and the Lawyers for Human Rights will cross-examine, and thereafter we'll then deal with your case.
Commissioner, may I simply comment slightly? I do not expect the Commission to overturn the judgment. That's not a suggestion. It's simply to establish the climate of what preceded the judgment against me.
Thank you. We'll deal with that tomorrow morning. I think unfortunately, Mr. Manuel, we are unable to finalize your evidence today. You'll have to come back tomorrow because those who intend cross-examining you say that they are not ready, and I think in all fairness, one should give them an opportunity of preparing for the cross-examination. And from what you're saying, Advocate De Vos, I suppose you say that you're going to need about an hour or two.
That is correct, Chair.
Mr. Brown, how long do you think you're going to need?
I would think about 2 to 2.5 hours, sir.
2 to 2.5 hours. Advocate Moran, you seem to be tempted to want to say something.
Yes, Chair. I have a personal problem. I have to go down to the Eastern Cape in connection with a funeral. I would have appreciated if this afternoon could maybe be made use of when Mr. Terry Crawford Brown has assembled his papers. Perhaps if he could start with his cross-examination this afternoon at 2 o'clock, that would certainly save some time.
Unfortunately, we do not agree with that approach. We first want to give the Lawyers for Human Rights an opportunity to cross-examine, and thereafter only deal with Mr. Brown. So the suggestion that you are putting forward now is it will not be possible for us to first start with the Lawyers for Human Rights.
As a Commission, please.
Thank you.